Hi everyone, and welcome back to our podcast, Workplace Compass, which is a series that's intended to help you navigate the Employment Rights Bill. I'm Jess, I'm an employment lawyer at the team here at VWV, and today I'm here with my colleague Simon, who is an experienced HR advisor from NQHR. Today we're looking at what's in the government's implementation roadmap, which has now been published on the bill, and crucially what the roadmap means for employers and HR teams.
Hi everyone, thanks for joining us. So it's fair to say this is one of the most wide-ranging employment law reform packages we've seen in many years. But with so much change coming on the horizon, the big question we're getting from clients is, well, what's coming, when's it coming, and how do we prepare for it?
Yeah, exactly. So as we know, the bill was introduced back in October as part of the government's Make Work Pay plan. And whilst it hasn't received royal assent yet, we do now have this detailed roadmap that gives us a lot more detail on the government's intended timeline for various consultations and then implementation of the key reforms. And so for the first time, that gives employers a real valuable window now to plan ahead with some more certainty than we've had before.
Yeah, and that's what we're really here to help with. So we're going to break down the key legal and HR implications of the changes that are expected between now and 2027. So let's start with a quick overview of what's coming first. So let's start with what's likely to happen soon after the bill becomes law. So these are mainly industrial relations changes.
Yeah, that's right. So shortly after royal assent, we're expecting the repeal of the Strikes and Minimum Service Act and most of the 2016 Trade Union Act. And there'll also be new protections for dismissal for taking part in industrial action. But, the bigger changes for employers, those are generally going to come later, and particularly from April 2026 onwards. And that's where we're going to focus today. Before we look at what's coming in 2026, it's also probably worth highlighting that many of these reforms are still subject to consultation. So the government has set out this phased approach to consultation and implementation, and we now have a timetable for when key consultation is going to happen.
Yeah, that's right. So consultations began this summer. So the early priorities included the return of the School Support Staff Negotiating Body, which is quite a name, a fair pay agreement for adult social care, and crucially, the detail of how day one unfair dismissal rights and probationary periods will work in practice.
Yeah, absolutely. So in the autumn of this year, the government is going to consult on that wide package of reforms. So we're going to see consultation on the detail of the fire and rehire provisions, the regulation of umbrella companies, rights for pregnant workers, and the ban on 0 hours contracts. They'll also look at bereavement leave and a set of trade union measures like electronic balloting and workplace access.
And then moving into winter and early 2026, we'll see consultation on flexible working, changes to collective redundancy rules, and how to tackle issues like tipping and blacklisting.
Yeah, so while the bill sets out the direction, the detail still, of course, needs to be shaped. And that means that there's going to be a window of opportunity for employers to engage with these consultations when they are launched. So this is a good opportunity to think ahead and also to start sort of stress testing your current policies before regulations land and plan where you might think you need to make some changes. So in terms of what's coming in 2026, April of that year is going to be the first milestone in the roadmap, and that's when several major reforms are expected to come into force. So one of the biggest is the change to statutory sick pay. So the lower earnings limit and the 3-day waiting period, those things will both be removed. And that means that many low paid or part-time workers are going to be entitled to SSP from day one, from April 2026.
And that's something that HR teams will definitely need to prepare for. So it's not just going to be updating payroll systems. You'll need to review your absence procedures, how you support employees who previously didn't qualify for SSP, It could also affect sickness reporting and trigger points in attendance policies, so they'll all need to be reviewed.
Yeah, absolutely, Simon. I think that is right. And in addition, we're also expecting day one rights for paternity leave and unpaid parental leave to come in from then. So, and in addition to that, there's going to be the establishment of the new Fair Work Agency, as you've mentioned, and that's going to support enforcement and guidance on all of this.
So, from an HR perspective, that's a good opportunity to revisit your whistleblowing policies to make sure you've got clear reporting channels, training managers to respond appropriately, especially now that the protections are going to apply from the outset of employment.
Yeah, absolutely, Simon. I agree with all of that. And then if you are looking sort of further ahead into 2026 and into October of that year, that's when the next big wave of reforms will be coming. So those include the really highly anticipated changes to the fire and rehire framework. And as I'm sure lots of our listeners will know, that's all about making it much harder to dismiss employees where they refuse to agree to proposed contractual changes. The government is going to consult on some of the detail on how this will work, but we already know that even with these latest raft of July 2025 amendments to the bill, that the fire and rehire reform is going to really make significant change in terms of how employers manage the processes of introducing contractual changes.
Yeah, I mean, at the moment, this is certainly something that employers use quite a lot in our experience. So this could be a real shift for employers trying to make contractual changes as part of restructuring or cost saving. So HR teams should start reviewing now, really, where flexibility is currently built into contracts and whether that's likely to help hold up in the
Mm.
new regime.
I think there's definitely an opportunity now to make the most of the time that we know that we've got ahead of us before the law changes, and make sure that you're in the best possible position as an employer well ahead of October 26, if at all possible. So yeah, keeping to then what else we can expect to see in October 26 then, we've also got the new duty to take all reasonable steps to prevent sexual harassment. That's due to take effect. That's going to be another big one for employers, because obviously, as we know at the moment, there's a duty on employers to take reasonable steps, but not all reasonable steps. So there's going to be an increase in burden on employers from October 26. And there's also going to be this separate duty, this standalone duty, not to allow third-party harassment of staff, and that's going to be coming in at the same time.
Yeah, so that's a really big one. So that means moving from being reactive to proactive. So that's not just responding to complaints, but also being shown you've taken real steps to prevent harassment happening in the first place. So that's going to involve training, policies, leadership, culture, risk assessments, and how you investigate any possible alleged sexual harassment.
Yeah, absolutely. So that's a real big one. And we know that lots of employers are already doing a lot of work in this area, given the October 24 changes and the introduction of the duty to take reasonable steps. So for lots of employers, it's kind of cementing a clear direction of travel in this area. But yeah, definitely it's an area where employers really need to get stuck in if they haven't done that already, and start making changes to ensure that they comply with the current law and the new law when that takes effect. So yeah, to wrap up then, I suppose on October 26th, the other bits and pieces coming in there include some stronger trade union access rights. So that will include physical and digital access to the workplace, new tribunal time limits, and fair pay agreements for adult social care. But I think, yeah, for most employers, the changes we've mentioned, so the SSP, the fire and rehire, and harassment duties are ones that lots of employers are going to want to be focusing on now.
Yes, so exactly. If you're prioritizing resources, those are the three areas really to get ahead of. And looking slightly further ahead, there's another big set of changes expected in 2027, and we'll tackle those in part 2.